Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we explore the world of innovation, creativity, and intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the successes and failures of others so you can protect your inspired ideas. Small business owners, I salute you. You are truly the backbone of America, and you keep things running. I'm here to help you. And that's what I hope I do in this podcast. Please leave me comments if I'm helping, if I'm not helping, what you want to see more of or less of. So we are here to talk about how to leverage your inspiration and succeed at making the world a better place. Once again, before we get started, I'm an attorney, and this is not attorney-client privilege conversation. This is a podcast, and nothing in this podcast should be construed as creating an attorney-client relationship. So, please join me on this journey as we explore the power of inspiration and how to turn your ideas into reality. We're on week 2 of our 13-week journey to learn how to leverage your inspiration. We're going to talk about strategically using the patent process to prepare a winning patent case. So Sun Tzu, I hope I'm saying that right. I don't speak Chinese. From The Art of War, he says, some can struggle to a victory, and their whole world may praise their winning. This demonstrates a limited ability. Win as easily as picking up a fallen hair. Patent battles. So when you get a patent, what your right is, you have a right to sue. Nobody who gets a patent wants to sue. They want to figure out how to make money without suing. And that same kind of strategy is in war. And so The Art of War, I don't know if you've read it. I hope you have. When you read it, you say, wow, I can apply that in this struggle or that struggle. It's just been a timeless classic. And so patent battles can be won even before they start. I sat down with some successful patent litigators to find out what is the perfect case and how I can, as a patent attorney preparing patents, how I can prepare the best case for them to enforce my clients' patents. So the strategy I learned that I will share with you can save you millions of dollars and make you millions of dollars. Preparation and planning for battle can avoid battle altogether. This is true in patent battles. With a winning strategy, even large companies might not want to fight with you, but will work with you so you can both make millions of dollars instead of spending millions on attorneys to fight in court. One of the analogies that I've used is that a patent is like a cannon on a fort, but this cannon is cemented in place. Once that patent is granted, it can only shoot where it's aiming. You can't move it. And those are the patent claims. We've talked about patent claims some already, that if an infringer is within the scope of your patent claims or within that scope and range of that cannon, then you can threaten someone with a lawsuit to stop their production, force them to pay you money, and that's what the patent covers. Now, so the winning strategy is this. When a patent application reaches that point where you get the allowance, the patent process, it's examined, and then it's 90% or around 90% of the time, they have at least one rejection. Then the attorney asks for reconsideration based on changes, arguments, and it gets examined again. When the examiner agrees that the patent is ready for allowance, ready to be granted, there's a period of time, there's still some things to be done, before it's granted. During that time period, if you file another patent application, that one can continue your patent pending. You can continue keeping that patent alive. And that is like a cannon where the cement has not set and you can adjust it. So when you file that patent application, you don't know the exact target that you're shooting at until someone infringes your patent. Now, when somebody infringes your patent, then you know the target. You know this is exactly what they're doing. If you have a patent pending, you can, as I might say, adjust your cannon. You can target them specifically with your claims. Now, you can't sue unless you have a patent issued. So you have a pretty empty threat in a way if you never get it. Well, you have an empty threat if you never get a patent. If you just keep getting rejection after rejection and you're never going to get through the patent office, that doesn't worry companies as much as if you have a patent and you also have a patent pending. Because if they can argue, well, I'm just outside the range of your patent, then you've got another patent application that you can say, well, maybe you're outside of the range of this one, but I'm targeting you, so we're going to get you. And in that kind of scenario, it's much easier for the litigators to get a settlement. And that's what you want, is you want to end the case. Like the Sun Tzu quote, yes, it makes a great story if you spend millions of dollars and win the battle. But wouldn't you rather win as easily as picking up a fallen hair? You present your case and they say, all right, let's work out a deal. Instead of spending millions of dollars and years of your life pulling your hair out, like there have been movies made about that process. So that's the winning strategies. And as I discussed before, there's another reason why you may want to do this strategy is I mentioned that the patent laws, whether interpreted by the court or handed down from Congress, can change over time. And if you have a patent pending and a case comes down and says, well, the way this patent claim is written, it is not valid, then, and that's a phrase in your patent claim, but you've still got one pending, you can still get the patent if you can get a patent claim accepted that doesn't have that offending phrase or whatever the court says can't be done. Now, I want to talk a little bit about the path through the patent office. So the default path in time can take anywhere between 25 months to 110 months for a patent to get granted. There is an expedited path with an average of 6.7 months for applications that are granted under this expedited program. As I mentioned before in a previous podcast, there's a notice of allowance, and the Patent Office measures how many patents make it through and are given a notice of allowance within 2 reviews or after 2 reviews or less from the Patent Office. And for that statistic, there are 56%. There's an expedited program that you can get into. It has a filing fee that's extra, but it has a 56% success rate of getting the patent granted very quickly in terms of patents, in under a year. And since you can't enforce a patent until it's granted, one of the strategies is to go through that patent process quickly, and then you've got a granted patent. It's easier to license a granted patent. It's, of course, you can enforce a granted patent much better. and then also keep that patent pending for this strategy to work. So one of the things that is important for you to consider, I mentioned in the previous podcast that some patents are more valuable at the beginning of their term, and some patents are more valuable at the end of the term. Thinking of that strategy for your business, a patent attorney might know generally what is going to work for you, but you know the timeline and the timing of what you expect to happen in your business. And your patent strategy can align to that timing, but it can only align to that timing if you discuss it with your patent attorney, who has the options to select different ways to get things done. And that's why understanding there isn't just one path in terms of timing to get through the patent office. So talk to your patent attorney about what is the most valuable time for your patent, whether it's the beginning or the end of the 20-year term. And when you work with a patent attorney, the goal is that I'm trying to help you with, I hope it's helping, is to get enough knowledge so you can share with them the critical information. Hopefully they're already asking that information, but continuing to check in on those critical pieces of your business plan and how they can affect your patent application, or how your patent application can be aligned to your business plan in terms of timing, in terms of cost, and results from the patent office. Those are the things that I'm hoping for you, and I hope you'll join me next week as we continue to talk about patent process, patents, and leveraging inspiration. So this is Wayne Carroll with Leveraging Inspiration, the Inspired Patent Podcast.
Navigating Silicon Valley and all of those things. So I would say that it's a much more diverse background of people. And I mean diverse from